Alabama v. White, Supreme Court, 1990. Justice White delivered the opinion of the court. Based on an anonymous telephone tip, police stopped respondent's vehicle. A consensual search of the car revealed drugs. The issue is whether the tip, as corroborated by independent police work, exhibited sufficient indicia of reliability to provide reasonable suspicion to make the investigatory stop. We hold that it did. On April 22, 1987, at approximately 3 p.m., Corporal B.H. Davis of the Montgomery Police Department received a telephone call from an anonymous person stating that Vanessa White would be leaving 235C Linwood Terrace Apartments at a particular time in a brown Plymouth station wagon with the right taillight lens broken, that she would be going to Dobby's Motel, and that she would be in possession of about an ounce of cocaine inside a brown attaché case. Corporal Davis and his partner, Corporal P.A. Reynolds, proceeded to Linwood Terrace Apartments. The officer saw a brown Plymouth station wagon with a broken right tail light in the parking lot in front of the 235 building. The officers observed respondent leave the 235 building carrying nothing in her hands and enter the station wagon. They followed the vehicle as it drove the most direct route to Dobby's Motel. When the vehicle reached the mobile highway on which Dobby's Motel is located, Corporal Reynolds requested a patrol unit to stop the vehicle. The vehicle was stopped at approximately 4:18 p.m., just short of Dobby's Motel. Corporal Davis asked respondent to step to the rear of her car, where he informed her that she had been stopped because she was suspected of carrying cocaine in the vehicle. He asked if they could look for cocaine, and respondent said they could look. The officers found a locked brown attaché case in the car, and, upon request, respondent provided the combination to the lock. The officers found marijuana in the attaché case and placed respondent under arrest. During processing at the station, the officers found 3 milligrams of cocaine in respondent's purse. Respondent was charged in Montgomery County Court with possession of marijuana and possession of cocaine. The trial court denied respondent's motion to suppress, and she pleaded guilty to the charges, reserving the right to appeal the denial of her suppression motion. The Court of Criminal Appeals of Alabama held that the officers did not have the reasonable suspicion necessary under Terry v. Ohio to justify the investigatory stop of respondent's car, and that the marijuana and cocaine were fruits of respondent's unconstitutional detention. Adam v. Williams in 1972 sustained a Terry stop and frisk undertaken on the basis of a tip given in person by a known informant who had provided information in the past. We conclude that, while the unverified tip may have been insufficient to support an arrest or search warrant, the information carried sufficient indicia of reliability to justify a forcible stop. We did not address the issue of anonymous tips in Adams, except to say that this is a stronger case than obtains in the case of an anonymous telephone tip. Illinois v. Gates dealt with an anonymous tip in the probable cause context. The court there abandoned the two-pronged test of Aguilar v. Texas and Spinelli v. United States in favor of a totality of the circumstances approach to determining whether an informant's tip establishes probable cause. Gates made clear, however, that those factors that had been considered critical under Aguilar and Spinelli, an informant's veracity, reliability, and basis of knowledge, remain highly relevant in determining the value of his report. These factors are also relevant in the reasonable suspicion context, although allowance must be made in applying them for the lesser showing required to meet that standard. The opinion in Gates recognized that an anonymous tip alone seldom demonstrates the informant's basis of knowledge or veracity, inasmuch as ordinary citizens generally do not provide extensive recitations of the basis of their everyday observations, and given that the veracity of persons supplying anonymous tips is, by hypothesis, largely unknown and unknowable. This is not to say that an anonymous caller could never provide the reasonable suspicion necessary for a Terry stop. Simply put, a tip such as this one, standing alone, would not warrant a man of reasonable caution in the belief that a stop was appropriate. As there was in Gates, however, in this case, there is more than the tip itself. The tip was not as detailed and the corroboration was not as complete as in Gates, but the required degree of suspicion was likewise not as high. Reasonable suspicion is a less demanding standard than probable cause, not only in the sense that reasonable suspicion can be established with information that is different in quantity or content than that required to establish probable cause, but also in the sense that reasonable suspicion can arise from information that is less reliable than that required to show probable cause. Adams v. Williams demonstrates as much. We there assumed that the unverified tip from the known informant might not have been reliable enough to establish probable cause, but nevertheless found it sufficiently reliable to justify a Terry stop. Reasonable suspicion, like probable cause, is dependent upon both the content of information possessed by the police and its degree of reliability. Both factors, quantity and quality, are considered in the totality of the circumstances, the whole picture, that must be taken into account when evaluating whether there is reasonable suspicion. Thus, if a tip has a relatively low degree of reliability, more information will be required to establish the requisite quantum of suspicion that would be required if the tip were more reliable. The Gates Court applied its totality of the circumstances approach in this matter, taking into account the facts known to the officers from personal observation and giving the anonymous tip the weight it deserved in light of its indicia of reliability as established through independent police work. The same approach applies in the reasonable suspicion context, the only difference being the level of suspicion that must be established. Contrary to the court below, we conclude that when the officers stopped respondent, the anonymous tip had been sufficiently corroborated to furnish reasonable suspicion that respondent was engaged in criminal activity, and that the investigative stop, therefore, did not violate the Fourth Amendment. We think it also important that, as in Gates, the anonymous tip contained a range of details relating not just to easily obtained facts and conditions existing at the time of the tip, but to future actions of third parties ordinarily not easily predicted. The fact that the officers found a car precisely matching the caller's description in front of the 235 building is an example of the former. Anyone could have predicted that fact because it was a condition presumably existing at the time of the call. What was important was the caller's ability to predict respondents' future behavior because it demonstrated inside information, a special familiarity with respondents' affairs. The general public would have had no way of knowing that respondent would shortly leave the building, get into the described car, and drive the most direct route to Dobie's motel. Because only a small number of people are generally privy to an individual's itinerary, it is reasonable for police to believe that a person with access to such information is likely to also have access to reliable information about the individual's illegal activities. When significant aspects of the caller's predictions were verified, there was reason to believe not only that the caller was honest, but also that he was well informed, at least well enough to justify the stop. Although it is a close case, we conclude that under the totality of the circumstances, the anonymous tip, as corroborated, exhibited sufficient indicia of reliability to justify the investigatory stop of respondent's car.